As ever, by name, rank, serial number as you choose, starting on my left.
Thank you. Good morning, Chair. Good morning, Committee. My name is Estelle Dehon KC. I'm a public law barrister specialising in environment and climate and planning with Cornerstone Barristers.
Thank you. Just to rewind a little bit, I mean, the review every 5 years, would that be a better approach? I mean, should the government have accepted that? Maybe Estelle Dehon?
Yes. Certainly from my perspective, it would have been better had that been fully accepted. So accepted and backed by quite a strong obligation, not necessarily a full legal obligation, but a very strong commitment to 5-yearly reviews. The technology in this area is moving extraordinarily quickly.
That's a good argument for having reviews, yeah.
And that is one of the strongest reasons for having reviews. Yeah. Also, the extent to which we are capable swiftly of fixing some of the difficulties will inform then what planning policy needs to do going forward. So if we do well on fixing some of the transmission difficulties and getting more grid capacity, then policy can shift to other areas. But if we're doing poorly, then it needs to change more quickly. So both those things really require 5-yearly reviews.
Thank you. Thank you for that view. Estelle Dehon, and then I'll go to Julia Prescot.
Thank you very much. Two main points to make in relation to this. The first is that it is absolutely crucial, in my view, for communities to be able to feel like they have properly engaged with the system. And you're right, Chair, that to a certain extent in the current system that's not necessarily felt. And there is a tension between the requirement to move swiftly, which will be achieved by, for example, more use of presumptions, more centralised or regional planning, and that community engagement. But I think it is feasible to get proper community engagement, and in particular it would have been better had the NPSs more strongly encouraged right at the outset very strong stakeholder engagement by those bringing projects forward in a way that was demonstrable and that added planning benefit, so was a value in the planning balance to the developer to do that work. The second thing, which I think is an important point, and picking up on what Robbie's just said about community benefit, there is a difference between community benefit, in particular payments to communities, and getting that community's support. To a certain extent, community benefits will assist in that, but they are not the same thing. And many communities who have opposed development have not been swayed by community payments or community benefits. I think there is a role for community benefits, a strong role, and if benefits are taken more broadly than just payments, then that's definitely the case. But the committee needs to be aware that as things presently stand in law, the Supreme Court has made it clear that any payments to communities of benefits, financial, for example, benefits for hosting a wind farm or a solar farm, cannot, as a matter of law, be taken into account in the planning balance. And if Parliament wishes to change that position, it cannot do so just by policy. It will have to legislate to say that that has weight in the planning balance.
Do you have a view on
that? My view is that I think it would help to legislate, but that should not be seen as the silver bullet for dealing with the difficulties that communities face.
So you're saying legislate to enable benefits in the planning, but also to be mindful that benefits are not necessarily support.
Correct. They are not the whole story. And if they're essentially at two ends of the same spectrum, so if the benefit can come in with planning weight, that's great. But if that very early stakeholder engagement, ideally with a cross-section of the community, can also be given planning weight, and that can be done without, just by policy, then those two things, I think, will improve the system. Yes, I absolutely support that. And in fact, the weird upshot of how, especially the solar threshold has been placed, is that we're seeing 49.9 megawatt solar farms coming forward under the outside of the NSIP regime, and in fact having the capacity potentially to generate more than that when they're built out. But that leading to a difficulty, because that may be meaning that they have to go through an NSIP type process in order to generate to the extent of the capacity that they have. So even if the thresholds don't move, there should be some way in which, if you happen to be able to generate a little bit over the threshold, that you would be capable of achieving consent for that without having to fall within the NSIP regime.
I mean, there's government proposals around the NSIP reforms to speed up on some of these issues. What reforms should the government prioritise to reduce the timescales for granting development consent orders?
Yes, I'll give you three good things that they can do, but let me just say one thing on what you were talking about with Julia in relation to community benefit. I think what's been missed on energy infrastructure in particular is the narrative. No one could suggest that the narrative around hospitals is not wholly positive and that they are a good thing and that they should be built out. But the narrative, unfortunately, that has developed around energy infrastructure is not that positive. And it is possibly for that reason in particular tied with the fact that it is absolutely clear on every possible level, with every type of evidence, scientific evidence, economic evidence, community evidence, that in fact this infrastructure has to be built out with rapidity, that we need to shift the narrative quickly. And one of the ways to do that is community benefits. But you asked about what planning reforms can be put in place for this infrastructure to come forward quickly. One of the reforms that I had suggested was important, which is certain critical national priorities being designated, including grid infrastructure being part of that, has come out in the new energy NPS. But of course, that's for national infrastructure. There are projects that are going through planning outside of that process, and it would be good if that critical national priority could also be applied within what I'll just call the Section 78 or the town and country planning process. Second, in relation to solar and battery installations in particular, there needs to be clarity across all parts of planning, both national infrastructure and town and country planning, that position of that infrastructure close to a grid connection is something that should have positive planning value. And I can give you a lot of examples about where at the moment there is significant confusion around that, about where it has in some instances been taken into account positively, in some instances not, and I'm afraid that the recent NPS or what's been published in the past week hasn't solved that problem. So it would be very good if that could be clarified. And then finally, we may get into this in some more detail a bit later, but that perceived conflict between solar/battery installations and agricultural land needs to be addressed in the planning system. Be updated. And we have really good experience now in how community consultation can be done well. For example, there's... Yes, and quickly. There's a system of local area energy planning. I don't know if you've come across this, but it's a way that very, very small local areas, and wide areas, but very small local areas, can rapidly, in a data-driven way, bring together a local energy plan for their areas. And that has a lot of quite detailed community consultation and has been able to be undertaken rapidly. There's good practice everywhere, and that should feed into the guidance question. Yeah. So I think the intention was for much more, especially solar, to go through the national infrastructure route. And interestingly, what has come about is a proliferation of 49.9 megawatt under the Town and Country Planning Act schemes coming forward. And that's because that route is seen to be a more efficient and better route if you want to do a scheme that is
smaller scheme is determined by the local authority, not the national. So the local authority is more likely to be sympathetic to the proposal than if it were to go through the NSIP regime.
I don't think it's about sympathy. I think it's about the overall time that is taken within the system.
I think and a more likely acceptance of the proposal. Do we know any? What are the stats?
I don't have statistics. So I can't help you on that.
I can help there. I mean, I think certainly to date.
Yes. So to a certain extent, that is about size, although so extent of what the solar panels will cover. And if the Town and Country Planning Act scheme or route is chosen, i.e. you're underneath the threshold, then you'll go to, that's the 50 megawatt threshold, you'll go through the normal local planning process, you'll make an application to the local planning authority. That will be considered in the first instance by a planning committee, and as Robbie says, there'll be an opportunity for people to object and maybe to speak, but that's usually limited. It's really after the decision-making process, if, for example, there's a refusal, that there's significant potential community engagement with the appeal process that developers go through. That's before the planning inspectorate, either via written representations or a hearing or a planning inquiry. And that's when local communities tend to have a lot of opportunity to have their say, to actually physically speak. In the NSIP regime, as Robbie was saying, there's a completely different initial decision-making process. That is a full 6-month, thought-through, but very heavily written process. And the interesting thing is that communities sometimes feel if they're not able to say, to articulate physically to a human being what it is that their concerns are, then they feel less well represented within the process. And that's something that the NSIP regime, I think, has struggled with a little.
Where you've got solar and battery next to a grid connection, that should have a positive planning value, and that needs to be greater clarity on that, and the need also for greater clarity on the use of agricultural land, I'm guessing of different grades of agricultural land. What tools could give that clarity?
Yes, so I'll differentiate between the National and the Town and Country Planning Act process. In the National Infrastructure process, really we had hoped that the energy NPSs would have given the clarity about grid connection. That has unfortunately not happened, so that's a missed opportunity.
Another level of guidance, is that what I'm saying? If it hasn't happened,
it hasn't happened. It hasn't happened, and maybe if there was another level of guidance, or if there was, I suppose, if there was a practice of giving that weight, because the NPSs don't say you shouldn't give it weight, they just don't say that you should. And that
this committee can make recommendations to the government to take action. For example, should we be saying to the government, it would help if you could issue specific guidance on this?
Yes.
Okay.
Yes, exactly. And that guidance, I suppose that guidance could apply across the piece. For Section 78, definitely, there is the potential for the planning practice guidance, which is very old in this area. Some of the planning practice guidance is 2015.
So we should
that needs to be updated.
Update planning guidance.
Specifically, that proximity to the grid connection should weigh in the balance in the planning process, and in particular is a good reason for a developer choosing a particular site over another site, so that you avoid all the debate about there's an alternative site, but that's far away from a grid connection.
Okay. And in relation to agricultural land, how would clarity be given there?
Well, the easy way to do that for the Town and Country Planning Act system is for the planning practice guidance to be amended. The current planning practice guidance, as I say, very old, says something incredibly unhelpful about agricultural land. It sort of suggests that you have to be able to demonstrate that no agricultural land will be used, and if you are using any agricultural land, that you have very good reasons for doing so. That needs to be removed completely and shifted on its head, in my view. For the NPS system, unfortunately, what the current suggested reviewed or revised NPSs say about agricultural land and solar and battery is, in my view, unhelpful. It would be great if that was amended, but it's unlikely to happen. So maybe some sort of guidance sitting under that ameliorates it would be useful.
So to both Robbie and Juliet, do you agree with the premise of what Estelle is saying, that updating guidance details in these two areas would help remove inconsistencies?
Yes, I think I do.
I think it would
be clear that the greatest challenge to food security is climate change impact. And there is lots of data that even if you push solar to the extent that the government wants, that there is very little impact that could have on food security overall for the United Kingdom.
And I
actually plays into that overall lack of confidence.
To a certain extent, yes. And I think you put your finger on a very important aspect which has been left out of the planning system, but I think is increasingly coming into it, which is that we don't really, there's very often good analysis of what the cost benefits are of a certain scheme. But the disbenefit or the costs to communities if you fail to bring something forward or if you fail to act in a certain way aren't really quantified. And that, I think, the kind of overall climate impacts, if you say, of not acting, I think are going to need to be costed a bit more strongly.
And Estelle, you said earlier about the Supreme Court, this is question 6, by the way, Chair, the court judgments that says you can't take community benefits into consideration
as a planning matter.
Does that mean if you've got 2 planning applications for a wind turbine in a village, and one of them is going to let the people in the village have discounted electricity, say in a local grid, and the other isn't, you don't take into account that community benefit in your planning decision?
Nothing that is unrelated to what is called land use can be taken into account in the planning balance. So direct payments, certainly not. That type of benefit is very tricky. And often it's not taken positively into account in the planning balance either.
We control, Estelle, you're the lawyer.
In my head.
Yeah. No, think.
I might think about that. But yes, I think, just to echo what's been said, I think that is important. But the role that statutory consultees play is a general good in the public interest. And so it is not a role that should, in my view, be wholly paid for by developers. That is, it's a general good for all of society that these statutory consultees engage robustly in this process.